Members of the military are at risk of losing their careers, their livelihood, for behavior that is often not even a crime in the civilian system. That's why you need to know the facts. You need to know your options, and you need the help of experts when facing military justice.
Welcome to Military Justice. I'm your host, Jim Buchanan. Our guest today is Jonathan Crisp, who is a trial attorney specializing in military law at Crisp and Associates. Jonathan, thanks for joining us today.
Thank you much.
Let's start with this. Deploy or out of the service policy. Explain exactly what does that mean?
Simply stated, it is the Department of Defense's policy on retaining non-deployable service members. Okay,
and then how serious is that for a military service personnel and their families?
It basically means a loss of a career. It means a loss of your job, any military benefits, pension, everything that you've potentially worked for upwards of 20 years.
So in other words, you either are going or you're not going.
Correct, correct.
You're not even asked, or you're just told. You have to do that.
Right, as every service member knows, you're scheduled for a deployment, you're going to deploy, and DoD has concerns that there's a significant number of individuals that are maintaining slots or positions that are unable to deploy, and it puts a greater stress on those who can. And so they want to get a more mobile, agile force and a more deployable force.
And when you say if you can, that brings up the subject of people who may be injured. Are they still able to serve or be deployed?
Well, in certain circumstances, yes. So a lot of it's going to depend upon how rehabilitatable the injury is, the time period in which the injury can be rehabilitated. They seem to have put out 12 months as sort of a guideline. Can you do it within a 12-month period? Can you deploy within that time period? Even prospectively, they're going to say if this person can't deploy within 12 months and the injury is fairly recent, that still could be a cause for separation.
Now, what about the effect of morale on that?
I think it has the ability to have both a positive and a negative, right? So it's two sides of the same coin. You're going to see individuals who have deployed multiple times who will say, hey, listen, I've done this many times, and this individual over here, he's been injured, he's been sitting in a transition unit for ages, and we're bearing the brunt of it. And so they're going to feel better about this policy because they're going to feel like they've done the most. But then on the flip side, you have an individual who's genuinely injured, who has been injured in the line of duty, or people who are deploying are going to be concerned about, well, geez, what if I get injured when I'm deployed, and are they just going to dispose of me as if I'm fungible?
So what's your advice then for personnel defending administrative separation in these kind of proceedings?
The advice I have is you're going to need to be responsive in your answers to whether or not this is a truly rehabilitatable injury. Timelines are going to be hugely important, getting independent medical opinions that may challenge what the military doctors are asserting, and being aggressive in your approach.
And then beyond that, what other things would you advise personnel to do?
What I'm going to do is I'm going to talk to an individual and say, what is your goal here? You know, do you want to stay in? And if you want to stay in, my advice is going to be different than if an individual says, listen, I don't feel like I physically can, and I don't know if I want to continue this fight. So what I'm going to do is say you need to be immediately responsive to the notification. The more time we have, the better it's going to be for us to be able to put a coherent and cohesive defense. It's not unlike what I would consider this to be a medical evaluation board, where an individual is going to be identified and potentially separated based on that notice as well. So it's very similar in that sense.
Well, specifically though, then how can Crisp and Associates help?
We can help with experts. We can help with identifying the things that they are looking at to ensure that the person is responsive to the perceived deficiency, whether it's a mental health issue, whether it's a physical issue. We've done a number of these and been very successful in keeping soldiers and quashing an MEB. And in those instances when service members just want to be medically separated, assisting in that process as well.
And then when should they contact you?
Immediately.
Right away.
Yeah, the more time we have, the better it's going to be for us to, put a good defense together.
And speaking of time, that is all the time we have for
Thank you very
today.
much.
Thanks, Jonathan, for joining us. Thanks for watching Military Justice. If you're interested in learning more about today's topic, go to mymilitarylawyers.com. Remember, you need to know the facts, and you need to know your options, and you need the help of experts in facing military justice.